We're going to talk about mechanics liens. What is a mechanics lien? What is the legal basis for it? And by the way, mechanics lien used to have an apostrophe in it. It doesn't anymore, according to the Contractors License Board. So that's not a mistake. When do you need it? How do you can make sure that you can file it? The time limits. How do you foreclose on it? And then we talk about stop notices, which is the equivalent of a mechanics lien. How's it different from a mechanics lien? And that's the kind, this is what you use for public projects. So those who are going to get into government contracts and public projects, or they are there, should pay attention to this. How to make sure you can file it. Again, the time limits to consider. How do you foreclose on it? And then we talk about how to minimize exposure to any issues that could arise, like not getting paid. So with that, very briefly, my firm, I'm the founding attorney. There's 5 of us attorneys and a lot of other good people that help us here. We do business and construction law, mainly litigation, lawsuits, but we do a lot of preventative work too. So trying to keep good folks that do good work out of trouble. We our motto is small firm value, but large firm expertise. We all come from large firm backgrounds. I've practiced construction law since 1999. I have a master's in physics, and that's how I got into construction law, because of a technical background on construction defect cases, where I started with large construction companies such as Turner, Whiting Turner. I've represented all of those. We were doing a lot of defect cases. They needed someone with a science background to be able to talk to them, talk to experts, like a couple of them that we have on the call today. We all the attorneys have at least 20 years experience. And then we do a lot of preventative law, as I mentioned. Our areas of practice include construction, litigation, so a lot of defect suits, but those are not so much as anymore. A lot of our disputes are payment disputes. Someone doesn't pay someone else. Contract disputes, collections, with mechanics and stop notices. And then we do the preventative stuff, advise you as to RMO, RME contracts, public versus project contracts. Course of construction advice. I mean, a lot of times we're hired because things go crazy during construction, and we come in and a lot of times we're able to calm things down. Engineering and architectural contracts. We have a lot of engineers and architects that are our clients, just from the preventative standpoint, licensing, bid protests, etc. We have been involved in a lot of, these are some of the things that I have been involved in. We've been involved in flood control channels, retaining walls, street cases where paving has failed. I was involved in the Disney Concert Hall case way back when it started. In the FIDM case, the Fashion Institute of Design and Merchandising, we do a lot of large-scale residential projects. I was involved in this particular one in Reno, Nevada. Sometimes we do hotels and businesses and shopping center. We were lucky because we were part of the Rams Stadium. A lot of you guys were in there, and we were listed as one of the preferred law firms for that project. And these are some of the other types of work that we do. And we represent contractors, engineers, and architects. With that, I'm going to hand it over to Rakaya to talk about her company.
Hello, everyone. I appreciate everyone for joining us this evening. I know it's been busy and holiday coming off a holiday. Thank you guys for being here. I am the general manager and owner of Coleman Equipment Rentals. We are an aerial equipment rental company. And basically, aerial is anything that puts people or materials in the air. Established in 2018, Coleman Equipment Rentals is a small, minority woman-owned aerial equipment rental company. We specialize in furnishing equipment for new and ongoing construction projects in Los Angeles, Orange County. Our massive fleet ranges from 13-foot scissor lifts to 185-foot ultra booms. In addition, CR offers mute training to ensure the equipment is used effectively, efficiently, and safely. We are located in Paramount, California, and offer quality equipment, rental, and excellent customer service for all your project needs. Meet the owner. I'm the owner and general manager of Coleman Equipment Rentals, also known as CER. I'm also a licensed JLG instructor, so I get people certified to use aerial equipment. With over 20 years of experience in construction industry, I oversee all daily operations functions for Coleman Equipment Rentals throughout the Southern California region. I hold excellent customer service and satisfaction to the highest standards at CER. Some of our services that we provide: bare equipment rentals, maintenance, light repairs, and mute training. Here's a few of my qualifications. I'm small business certified, minority, woman, local small business, community business enterprise, which would be the County of Los Angeles, small business certified with Metropolitan Water District, Port of Long Beach, City of Long Beach, Section 3. In addition with that, I'm a JLG MOOP operator trainer, Swinnerton Builders pre-qualified, PCL pre-qualified, LAUSD Small Business Bootcamp graduate, LACCD Bootcamp graduate, Liens Mentor Protege graduate, and I also was this year's GLAC Special Recognition honoree. Here's a few of the notable projects that I've furnished equipment for: Gerald Desmond Bridge in Long Beach, Google Spruce in Long Beach, Intuit Dome, several LAUSD projects, SoFi in Inglewood, Target, Chino, West Covina, Hollywood, Target, Carson, Redondo Beach, Westchester, UCLA, Hospital, Harbor Gateway, Cedars-Sinai, Beverly Hills, Kaiser Watts, which I'm currently working on with Swinnerton Builders, LA County Sheriff's Department, Lucas Museum, I've been out there since 2018, and quite a few LAX projects from to ITF West, Conrac, APM, Delta Terminal, the list goes on and on. That's a picture of one of my units at Destination Crenshaw, which was rented by Marvella Steel Placers, and also a piece of my equipment at the West Coast NFL headquarters at SoFi. Summary: our team of experts will work with you in determining the right equipment for your job. Your trust and partnership is very valuable to us. When you succeed, we succeed. Coleman Equipment Rentals, lifting you to new heights.
Okay. Thank you, Rakaya.
Thank you.
You have great qualifications, and I'm honored to be co-presenting with you. We're
Thank you.
also a woman-owned business, so keep that in your mind too. All right, so what are mechanics liens? So let me tell you, it's actually a right that's been guaranteed by the California Constitution. It comes directly from our Constitution. You can put a lien on a property for work that you do on a property. And the common sense reason for it is that contractors, engineers, architects, people who enrich a property somehow need to be able to get paid. So that goes for direct contractors, subcontractors, material suppliers, equipment lessors like Coleman here, laborers and design professionals. And design professional means engineers and architects. There could be a variety of different types of engineers, from civil to structural, geotechnical, that we have on the call today, as well as various design professionals. Everybody contributes to the project. They deserve to get paid. And this is for private projects. The most important distinction between a mechanics lien and a stop notice is that the mechanics lien is for private projects and stop notices are for public projects. So how to make sure you can file a lien? A direct contractor doesn't have to give a preliminary notice. So in other words, if your contract is directly with the owner, not with a prime, not with another general, but with the owner, smaller projects, or if you're part of a prime contractor and you're directly contracting with the owner, you don't need to give a preliminary notice. They can record a lien, a claim of lien. So what we're going to talk about is basically a claim of lien. 90 days after the completion of the work, or 60 days after the owner records a notice of completion or cessation. Okay, so those are the time limits you have to keep in mind, even for subcontractors that I'm going to get to next. Now, subcontractors and everybody else, now, even for designers and engineers, if your contract is not directly with the owner, a lot of times you'll see that the architect is the one that's hiring the design professionals. You kind of fit within the category of all others. Then you have to give a preliminary notice. When? 20 days from the start of your work. Can this notice be late? Yeah, but it will only count for 20 days prior to when you give the notice. So make sure you do it at the start of the work. Now, a lot of our larger clients routinely send these. And if someone comes back and goes, oh my God, you sent me a notice. No, it's just part of our policy and our procedure. And we just need to do it right at the beginning. So make it a habit to send these 20 days from the start of your work, okay? And then, as I said, you don't have to worry about the fact that a lot of the work you did is not subject. You can't bring that under a mechanics lien. Now, a lot of people think that once they file that claim of mechanics lien, or record it is the right way to say it, record it with the county, you have to record it, they think that becomes a lien. That is a wrong assumption. Do not think that. It will only become a lien after you file a lawsuit that goes to its conclusion. You get a judgment, then you can record a lien. What you put does become what attorneys call a cloud on the title. In other words, what that means is that, okay, the owner won't be able to refi, won't be able to get a second mortgage, etc., because this thing becomes like a stain on the title, right? But it's not a lien until you file a lawsuit. A lot of times what we find is that by the sheer recording of a claim of mechanics lien, you can get paid. A lot of times they get nervous if you're sending this, you have to serve it on the general as well as the owner. If there's a lease situation, that automatically is a breach of the lease, and they don't want that. So a lot of times, just by doing recording of a mechanics lien, you're able to negotiate. You have a very powerful weapon. And if you file it and they still don't want to pay you, now remember, 90 days after you record, after the date that comes back from the county, and it has a recording date on it, 90 days after that, it expires. What does that mean? If you don't do something on it, meaning if you don't file a lawsuit, what happens is I could go to court and say, this person filed a lien against my property. It was 100 days ago, 120 days ago. Judge, I want this to be released. And the judge, through some motions, they will release it because you'll show it's on the face of the lien that you failed to file a lawsuit. That is extremely important. A lot of people don't know about it. And make sure if you file a mechanics lien, what we do is our clients, we ask them, give us, when you get close to the end of your work on a site, just give us a heads up. We'll put the first 90 days for you to be able to record that mechanics lien. So we'll put something on our calendar for that. And then we put another 90 days from that day for filing of a lawsuit. A lot of times you don't even have to do it, but it's good to have it there and not become invalidated if you still haven't gotten paid. Now I'm going to have Rakaya talk to you about this California preliminary notice and how to fill it out.
Hello, everyone. So what you have in front of you is exactly what the California preliminary notice looks like. It is basically piggybacking on what she said and going off the 20-day prelim for suppliers and subcontractors, is that it's due within the 20 days of you being on the project. That's very important. Must be sent to the owner, the prime contractor, lender, if any, and it can be sent late, but we'll get into all those stipulations. California subcontractors, material suppliers, equipment leasers must send preliminary notices 20 days to the owners, prime contractors, and lender, if any. The notice must be sent within 20 days of first providing materials or labor. Okay. Typical questions regarding a 20-day prelim. What is a California preliminary notice? A California preliminary notice is a legal document sent on construction projects to provide information to the people in charge of payment. It is also known as a 20-day notice because it must be sent within 20 days of first furnishing labor or materials to the project. California's preliminary 20-day notice protects the right of the sender, to file a mechanic's lien or a bond claim if they are not paid. Preliminary notices are used widely in constructions. Most states require contractors and suppliers to send these notices in order to protect their lien rights. Do I need to send a 20-day notice in California? The answer is yes. California law requires almost everyone to send preliminary notices prior to recording a mechanic's lien, giving stop payment notice, or making a claim against payment bonds. Two specific parties are exempt from California notice requirements, as she mentioned earlier. A pure laborer is not required to give preliminary notice, or anyone with direct contractual relationship with the property owner is only required to give a preliminary notice to the construction lender if the project has a lender. When is the deadline to send a 20-day notice in California? For full protection, California requires preliminary notice to be served no later than 20 days after the claimant has first furnished labor or materials. A lien claimant who fails to provide notice within 20 days of first providing labor or materials must provide the notice at a later date. However, they will only retain the lien rights for materials or labor furnished within the 20 days preceding the late notice, as well as any contributions thereafter. Keep in mind that California allows contractors and suppliers to send notice early. You can even send preliminary notice before you ship materials. Can I file a lien in California if I didn't send a notice? California requires preliminary notice in order to preserve your rights to file a mechanic's lien. Sending notice late will reduce the amount that you can claim in a lien. For example, sending preliminary notice today will allow you to file a claim for any work or materials you provided in the last 20 days. However, if it's been more than 20 days since you provided labor or materials and you forgot to send preliminary notice, you won't have the right to file a lien for those amounts. If you don't provide a preliminary notice at all, you will not have the right to file a lien in California. What happens if I send a notice late? If I miss the required date, all is not necessarily lost. California prelims can be sent late, but not too late. California prelims can be sent late, but will only retain lien rights for materials or labor furnished within 20 days preceding the late notice. How do I send a preliminary notice in California? As described in our comprehensive write-up of the different methods of sending preliminary notice, it's generally not a good idea to send notices by return receipt requested unless you are absolutely required to. For many of the same reasons, you should not deliver your California prelim by hand. While delivering by hand may technically be allowed, it has problems. The main problem is proving that you delivered it. A key part of sending preliminary notice in California is to make sure you can prove you sent it, and more specifically, that you have the proof required by the statutes. This proof is called a declaration of delivery. You may also want to refer to what is needed to keep track of sending preliminary notices. Who should send a 20-day preliminary notice on a California project? In order to protect lien rights on private construction projects in California, the preliminary notice must be served on the owner, the direct contractor or GC, or construction lender. If there's a tenant on the property, you may also want to consider sending a notice to the tenant. In order to retain bond claim rights on public construction projects, California preliminary notice must be given to the public agency in charge, general contractor, and surety if it exists. If you do not know who the property owner is, learn how to find a property owner in California. Finding information for such of these parties on a construction project can be difficult. You have the right to request this information from the party who hired you. By making the request, you are protecting yourself. The best practice is just to make that request and do so as diligent as possible.
Okay. So this is a California preliminary notice. Thank you, Rukaya. And as you see, you have to have the construction lender, the owner, the direct contractor, and other information here. This information you can always find on the first page of your contract, or it should be there. If you don't have the proper contract for these, contact an attorney who can help you with these. And then the name and address of your company goes up to where the claimant is, the person who's giving notice, and generally you have to state what kind of labor, equipment, or materials you provided. You have to provide a description of the job site. Usually an address is enough. Name of the person or firm who contracted for the purchase of the labor, and that would be the person or the firm that you contracted with. So usually a general. And then the total price. Now, one thing is very, very important. Please keep in mind, for purposes of a mechanic's lien, which is based on this preliminary notice, you can only give them the amount of work, labor, and services that was actually provided to the site. Please do not include your office staff. I've seen people that include monies paid in the office, but we're paying our office this and that. That is not money that is actually going to provide service to the site. So materials, equipment, or service to the site. Don't include extra stuff, because including additional amounts that are not allowed by the statute would invalidate your mechanic's lien. And it is very, very important. Rukiah, did you want to say something? Tracy, would you mind if we finish and then answer questions? Is that okay with you? I see it. Tracy has raised her hand.
Okay.
Okay, thank you, Tracy. Rukiah, did you want to say anything else on this slide, or should I go forward?
You know what, on this slide, the only thing I just want to add in is just another helpful tip is if the person doesn't actually receive any notice, does it still count? And this is what the response was. In California, preliminary notice must be sent within 20 days. Actual delivery is not required within the period. The requirement is considered met if properly sent within that period. This is made explicit within California's code 8116, which provides the preliminary notice is deemed to have been given when deposited in the mail in an appropriate manner. So that's a concern of some people too. Like, how do I know if they got it if I sent it? You know what I mean? So I just want to put that out there as well. So all is not lost.
That's a very good question. I think look at the page before, which we discussed. The page after is what Rukiah was talking about before, a proof of notice, declaration. A declaration in California is a document that is signed under oath. If you say something in there that is not true, you're subject to prosecution for perjury. So it has actual criminal perjury charges. So please, please, please make sure everything here is absolutely true. So with that in mind, once you fill out this declaration, very simple, put your name up on top, put the name of lender, owner, and the direct contractor there, provide the date of place of service. In the place of service, you can say by mail, document deposited in US mail on such and such day, and you sign it and put the date and place that you sign under there. Now make sure you keep an actual copy for yourself. That is, tell your office people, do not ever send anything without keeping a copy, because that's your evidence. If it were me, I wouldn't just do it by mail, because mail can be a little goofy these days. So I would do it by mail. I would do it a certified mail, even though, a lot of places say it's not necessary. I would do it by certified mail, return receipt requested. And if I don't get a return receipt, somebody doesn't sign for it, guess what? We're going to get on the phone, see what happened, do whatever you can to make sure they get it. Because in California, and under the law, always, everybody who has a claim against it have to have notice and an opportunity to be heard. That's in the due process clause of the Constitution. So make sure your notice is right. That's the first step in getting the mechanics lien right, and then later being able to get paid. So this is an actual claim of mechanics lien. Rakaya, did you want to discuss this or should I? It's up to you.
You go ahead
Okay.
with that.
Okay, so this is, these forms are easily available on the internet. Don't pay for them. A lot of people, a lot of places you have, you Google and the first ones that come out ask you to pay for them. There's no need. They're available from government sites free of charge. Usually there's a form that's available that you can actually fill it online. So I would recommend you fill it online and then keep copies, etc. In this claim of mechanics lien, your name goes in number one because you're the claimant, your company is the claimant. So you have a claim, right? And then you have to put the county name there, and that's the state of California, obviously. Put the exact address there. Now, if you're working on two projects side by side, make sure there's two different addresses there, or if there's suite numbers that are different, or any kind of different, sometimes a project could be very big and it could take more than one address. Make sure you have the correct one here. And what this says is important, goes back to what I said earlier, that you need to have the right amount here. This says after deducting all just credits and offset, the sum of, and that's the amount you put there, together with interest at the rate of this much, etc., is due to the claimant for the following labor, material, services, or equipment. Again, nowhere does it say you can charge your secretarial staff's work to this. Please don't. I've seen those. I've seen a lot of those. Please don't. So you put the exact sum there, and then you just give a very simple description. What did you do? You provided, I saw an HVAC company. We provided HVAC labor and material and services. That's it. It doesn't have to be very, very complicated, but it has to be exact. It has to show what you actually did. And then it says, number 3, claimant furnished the labor or services or equipment or materials at the request of who? Who is that? That's the company you directly contracted with, okay? So it's a GC, or if you're a sub of a sub, it's that sub. They are the ones that requested. Name of and address of the owner of the property should be here. Again, this information should be on your contract. If your contracts do not have these information, please ask for them. Make sure the name of the owner, the name of the construction lender are on the contract. And then you put your own address, date it, sign it, and there's a verification that's required. We do this as part of our services in our office. And a lot of our clients just call us and say, hey, I just finished a project. It doesn't look like they're gonna pay me. We'll go ahead and get one of these recorded. And you have to have proof of service there. Proof of service is part of every legal contract, every legal document that gets presented to somebody, served on somebody. Served means you present it to somebody, you give it to somebody. And that's always part of those. So you have to fill out the name, who was served, the name of the company. If there's a title of a certain person there, you got to put it there, the address, and then execute it on the date, the city, the signature, same thing for the lender. Okay. You know what? This might be a good place to stop for. What do you think, Rukaya? For some questions on these,
yes, I think this
we get into
perfect.
stop notices. Yeah, please, Tracy. I know you had a question.
Can you hear me?
Yeah. Hi, Tracy.
Hey,
Mayar.
Tracy.
Hey, Rakaya. I have a quick question, Mayar. You
Yes.
talked about the amount that you put.
You're breaking up, Tracy. Can you get closer to the computer or something?
Telephone. Can you hear me now?
I can. Yes.
when you put the amount, you said don't put the amount for your office staff or something like that. But
Yes.
whenever our contract amount includes overhead and profit, shouldn't the contract amount go in there, which includes overhead and profits, which includes your admin and things like that?
Okay, so there are two issues here. One, are you asking for the entire contract amount? How much did you not get paid?
No.
No,
I'm
I
talking
know
about-
what you mean. I know what you mean. I'm gonna get it to the overhead and processing.
No. I mean for the prelim, when you prelim the job, when you send it out, you
Right.
put the contract amount on there. You don't back out the overhead and profit. You just do the total contract.
Oh,
amount,
that's
correct?
fine. That's fine because your overhead and profit in that kind of a situation is part of your contract. But what you
Correct.
don't want to do is, I had someone who said, well, my office had to spend this much extra time doing this and that and that and that. And I said, well, your contract already included the 20% OMP. So that is what you can't put on that. But your overhead and profit that you've contracted as part of your contract with the other party is fine to put there, okay?
Thank you.
You're welcome. Anybody else?
Good question, Tracy. That was a
Very
good
good
question.
question. Tracy always has good questions. Okay, anybody
she
else?
does.
I cannot see anybody. I'm trying to share, so I'm not really seeing any hands up or anything. If you have a question, just jump in. All right, so we'll move on. Okay, so now we get to stop payment notices. For a lot of you who are doing contracts on public projects, and public projects could be schools, school districts, could be directly working on some that are semi-private, working on the LAX now with the various projects that are going on for remodeling, etc. There, metro projects, a lot of these types of projects, Caltrans projects, those are all public projects. What is your recourse if you don't get paid? Your recourse in that kind of a case is a stop payment notice. That's California Civil Code 8500 to 8560. Basically, it says that you can file a stop payment notice with the public entity. And what that does is, again, you have to also, I know Justin's leaving, by Justin. Okay, you have to also give a preliminary notice. It's very important. Same thing. Rakaya talked about it. I talked about it. 20 days from the start of the project, give a notice that if you don't pay me, guess what? I'm gonna file a stop payment notice. Now, the stop payment notice basically tells the owner, that's the public entity, say it's Caltrans, say it's the state of California, University of California, the school district, etc. You're telling them, look, your contractor that you contracted with hasn't paid me. Keep that amount that I'm asking this contractor to pay me aside, put it aside so you can pay me. Don't pay them. So this really gets to the guts of the contractors because they don't like not to get paid. And the idea is, hey, you cannot get paid if I don't get paid. So one thing that I see a lot of, and I want to caution you against, is this. I've seen a lot of direct contractors telling the subcontractors, well, don't file it. It's okay. It's okay. We're getting you paid. We're getting you paid. I saw one situation where they actually delayed the payment so much that the 90 days expired and then the subcontractor couldn't file anymore. So do not do that. And don't be scared of these relationships that you have with the party being tarnished or losing that relationship. They got to pay you, they cannot pay you. So that's important. The exact same thing happens with the stop notice. You put 20 days, you give a preliminary notice, you get the stop notice form, you file that and send it to the owner, give a copy to the general. And what happens after that? Again, 90 days, you have 90 days to file that, and then 90 other days before you have to file a lawsuit or your stop payment notice will be invalid. Ultimately, courts will decide if it gets there, whether you're entitled to payment. And so this is again very important. If you don't give the preliminary 20-day notice and you don't have a direct contract, you're out of luck with stop payment notice. So it's a statutory remedy, meaning it comes from the California statutes, meaning the people sitting up there in Sacramento have written it. It's for benefit of someone who, again, furnishes labor, services, equipment, or materials, and it requires a written notice, the 20-day notice. It has to be signed again by the claimant or its agent, meaning an attorney, lien company, whatever, can do that. And then it has to be delivered to the public entity as well as a direct contractor. And then again, they have to set aside the funds to satisfy your claim. The idea is this: public entity is just the custodian of the funds. So what happens is usually if a fund is authorized by the state of California for Caltrans purposes, they have this fund sort of in trust with them, you know, they're just keeping it. So they don't have a claim to funds, they're neutral. And so they're required to dispense of it according to the right principles, right? So they're required to give it to the right people who did work or provided equipment or materials, etc. And public entity is not just a stakeholder if it improperly fails or refuses to withhold funds. So under the statute, the public entity has to withhold the funds. This is a preliminary notice for purposes of a stop notice. Again, I don't want to repeat the same thing over and over. Exact same thing. You have to give it. And as Rukhaya said earlier, this notice, you also have to give it to a surety. A lot of times the public contracts require a payment bond, a performance bond, and these bond companies have to be notified, because if you can't pay, they have to pay, right? So, or the bond of the other side has to be notified. So it's very important that you do that. You file the stop notice. Again, who must give it? Anybody who's a subcontractor or is not direct contractor. Laborer doesn't have to, as Rukhaya said earlier. And what that would mean is that, remember, laborers can put a lien for if they don't get paid. And Chris, I'll get to you in 1 second. I see Chris has raised his hand. So, and then claimant that has direct contractual relationship, direct contractors don't have to file it. Again, they have to give notice to the public entity and the direct contractor. Okay, so basically, almost the exact same thing as a preliminary notice that we give for purposes of a mechanic's lien. Its general description of the work has to be provided, estimate of the total price of the work provided, because remember, this is a preliminary notice. You're just starting your work, so you don't know how much it's going to end up being. You can put the price of the bid there. Sometimes they would agree to some change orders, and your end price might be more. When to give it? Again, 20 days. We talked about this a lot, so I think the 20 days, you guys are going to dream about it tonight. We've said it over and over again. I hope you dream about it, because I want it to just be sitting there and saying 20 days from the start, 20 days from the start, okay? And so failure to give it, what happens? You can't enforce your stop payment notice. You could still bring a claim against the bond. And don't forget, anytime they don't pay you for about 4 years, there's a statute of limitations on a breach of contract, is 4 years. But why waste such a strong weapon as a stop notice or mechanics lien and rely on a breach of contract? Because that is not as strong. And I see Carlos as well. We get to you. 15 days after the notice of completion is the time you have to give that. And if there's no recording of a notice of completion, 75 days after completion. But remember, there are time limits. So immediately contact somebody who knows about the time limits and they will help you with that. We have, if there's a notice of completion, acceptance or cessation, you can find that out from your county recorder's office. 30 days after that, it has to be filed. Otherwise, as we talked about, that's 90 days after you complete your work or the work has stopped. And then let's see, here's the form. And if you guys don't mind, Chris and Carlos, let me go through the form and then we get to you. Is that okay with everybody?
Yes.
Great. So the stop payment notice form, this is, I don't know why it says private work. It should be public work, but you know, the form should say public. But what we want to do is give the, again, name of the owner, construction lender, the amounts of the labor, material, total labor, etc. And then you want to go, verification is your basic declaration that you're saying, I verified this is, I'm saying that these are true. What I'm saying here is true. You still have another proof of service declaration, exact same thing as the mechanics lien. And before we get to a release bond, I will, you know, we will take some questions. Please tell us who you're directing your question at. Chris?
Yeah, thank you. So my question is the public entity, is that limited to only California public entities? Our main owner is actually the federal government, and does that, because
Oh, is it
it's
for federal?
does that mean none of this applies?
To the federal?
Mm-hmm.
That's a very good question, and I can look into that and get back to you. My understanding, and I will definitely look into this, please put your email address in the chat or look at my email address and send me or send it to Ellen and she'll forward to me. I haven't looked at that specific issue, but my understanding is if you're in California, you go with California law. But I will look into that and definitely get back to you on that.
Thank you.
You're welcome. And for you, I know you talked about designers. I haven't discussed designers lien here, but a designer's lien is the equivalent of a mechanics lien, can only be done during the time that your work is happening. After it finishes, then you can file a mechanics lien, but before, during the time of the project, you can also file what's called a designer's lien. Okay.
Okay.
Great. And Carlos, did you have a question?
Yes, can you hear me?
Absolutely.
Okay, great. So yeah, the question that I have is in regards to public works on the stop payment notice. So I have a situation where a contractor, kind of like what you described, is stringing us along on payment on additional work, this is change order work.
Yes.
It's been several months, keep saying, look, we're getting approval from the city, wait another week. Okay, fine. It's been going on, and they had a turnaround of employees. Obviously, that had cost for us to kind of, follow their lead in a sense of, look, we have a new turnaround of employees, new set of people working. We're trying to do our best to get it approved. Nothing has been happening. I contacted a lawyer. Obviously, the amount that they're trying to charge to just send letters it's astronomical. It's just the amount doesn't even make sense for us even, to
I
start getting in a fight with the general contractor. What I'm trying to get at is that if I file a stop notice payment, will that, interrupt anything that we have going on the contract? Because the job is not completed. We're in the final stages of completion. We have about, several weeks of work on there. We still haven't turned in the building or any of that. We are
Okay.
owed quite a bit of money on it. Let's just put a number to it, about $35,000. And, if I follow a 20-day, a stop payment notice, and we do have a 20-day preliminary notices submitted and all of that in place, would that, now disrupt anything that I have going on where I guess the city or the contractor, they're going to come after me, try to kick me out of the job. And now, we're going to be, and, like cats and mouses here fighting for this. And the way that I see it, if I follow I don't know what are the, limitations of the stop payment notice. If I do it prior, during construction, while I'm still trying to finish my obligation, because we got to deal with liquidated damages, and in all reality, everything that we have done up to date, we are there, but they just have not paid for any of the change orders that we have submitted, and it's going already on 4 to 6 months.
So I have not looked at all the documents, and I have not, I don't want to, I can give you some advice, but this is not legal advice specific to your case. And the reason I'm saying that is that I would be subject to malpractice if I gave you legal advice without looking at the entirety of the situation and all of the documents. All I can say is, first of all, whether it's going to disrupt your situation or not depends on your relationship with the contractor. But overall, the best situation is make sure you are documenting everything. Everything they're telling you, do letters to them, do emails to them, do confirm what they tell you verbally in writing with them, and keep very good record of what's happening there. Okay. You're right to bring a stop notice. As we said, usually does not, it doesn't end until you are actually, let me go back here, until the notice of completion has been filed 30 days after that, as well as notice of, or 90 days if a notice of completion has not been filed. So it appears like such a thing is not the case yet because the project is still going on. So
Correct.
all I can say is just protect yourself. And this is general to everybody. The more documents you have, the stronger case you have. When people come to us, I always say when they come to us, it's almost like there's a jigsaw puzzle that they've thrown up in the air, and then it falls on the ground. They put it in a plastic bag and put it on my desk. Hey, solve it. It literally is that way. That's what it is. And so we have to come after the fact and see what happened. The more pieces of the puzzle you have, the more you have documented everything they tell you, the more you write them a letter or email or even a text, but keep them all, okay? Hey, you just told us not to do blah, blah, blah. I want to confirm that and remind you that there's a liquidated damages clause. We don't want to be charged for that. See what I mean? Even if, and at the end say, if you don't agree with what I said, just let me know. If they don't let you know, if they do not dispute what you said, guess what? You can take that to court. I'm not saying you necessarily want to take it to court because it does cost a lot of money. Unfortunately, it costs a lot of money. But with that in mind, the more you're able to document and the more you keep everything, take pictures, the fact that they're delaying you, write it out. You know, you're going to come back and say it later, and they're going to come, and if they don't like you, are going to say all kinds of nasty things about the work that you did. That's what happens. But what you want to do is, hey, you're delaying me. This is just to inform you that you told us today not to do this and that. And then this is to inform you that we have not been paid, and you're required under the law to get us paid within a reasonable time after you have been paid. So please confirm that you have not get paid. See what I mean?
Okay, that's the only thing I haven't done, to ask them if they confirm if I'm paid, but everything else that you said, we have done it. You know, we have T&M tickets, time and material tickets signed by their, you know, the foreman,
Good.
the project
Good.
managers, the owners.
Good.
Everybody is aware, but, you know, but nothing's doing anything. And if I follow, you know, what they have advised me, another person like, just like yourself, through another cohort, if you will, mentioned that he's like, look, if you file the stop notice payment, gloves are off, and from there on, you know, you're gonna have more problems to do so, rather than trying to mediate this directly with them, which we have patiently waiting and patiently been following them with all of this in writing. But they're just giving us a runaround. Last week they told me, well, we're gonna give you the information last Friday. Nothing happened. Then on Monday, nothing happened. Now this Friday, and if it doesn't happen, then what other options do I have rather than lowering it up?
Yeah, just write it out. Send them an email. This is to confirm that you told us you were going to pay us last Friday and you did not. And you told us you were going to pay us last Monday, you did not. And that now you're saying you're going to pay us this Friday. If any of the facts that I'm saying here is not true, please let me know.
It's more of the Chinchorro approvals, because they're saying that they have to put them through the city, and the city haven't. I mean, I'm not even to the point where I haven't been able to build them. They haven't given me the approval, although they have given me authorizations to proceed, backed up by RFIs. I'm sure you know what RFIs
Right.
are.
Absolutely.
And also by time and material tickets and 100 pages of emails going back and forth of discussing the work and coordinating the work. So it's all well documented. But, you know, again,
Good.
you know, my thing was,
Good.
you know, if I do a stop payment notice now, I mean, you know, where that leaves me, that the project is not completed. It's not after.
Yeah,
30
you
days,
have to,
or 30 days.
you've given the preliminary notice, right?
Yes, ma'am.
A 20-day. Okay. Okay.
Yes.
Well, document, that's all I can say. And try communication. I always say, you know, works for everybody. Communication is the best thing you can do. Make nice, try to resolve, as opposed to going to an attorney, because it's going to cost you a lot of money. I'm an attorney, right? And I make my living being an attorney, but I always tell the clients, try to resolve, try to be smart about it, and make nice, and communication and things like that, because you don't want to get to a point that you want to talk to an attorney for preventative measures. You don't want to get into a lawsuit, because
Of course.
so much money. And people that come to me that have already been sued, and I have several people that even from NAMAC, you know, that have been sued, and they come to us, it's almost too late, but we do what we have to do. At that point, there's damage control. So try not to get there, and to not get there, you know, it's human nature that the more, try to be nice, but do what you need to be doing, but be nice. So what, you know what I mean? But Rukiah, you know, I don't know if you have anything to add there. I don't want to monopolize.
No, everything you said, you chimed in really good. It seems like he's doing his proper documentation. And unfortunately, the project isn't complete yet, so he can't do the next recourse. That's unfortunate for him. Just hopefully for him, everything pans out. Let's claim that, Carlos. And it looks like you're doing the right thing by keeping everything documented. And hopefully they get a bite of integrity and do the right thing and want to do what's right by you and other small contractors. Because people like that, they don't understand that that's a make or break for a company. You know what I mean? You still have to pay for your materials, still have to pay for your employees. And sometimes, you know, one job is supposed to sustain itself, but that's just not the way it goes. You know, money doesn't come in at the same time. So just keep on doing what you're doing and keep up the good work, Carlos, and don't lose faith.
Very good. Thank you, ladies.
You know, Carlos, you're not alone.
Oh, yeah, no.
We have at least
I mean,
10, we have at least 10, 12 of these in this office right now.
I
And
have,
it's the same thing. See, I talk about they will drag you along. So you're not alone, don't feel bad. But a word of caution, anybody who has not done a public contract, who wants it to get into government work, please talk to other contractors who've done it. If you don't want to talk to an attorney, talk to other contractors who've done it. Try to do it the right way. Try to get some advice. It's full of not just, holes, but really big, canyons you can fall into.
Also, in addition, what I do, Carlos, is if I'm going to go get in bed with someone, is I like to look at the company that I'm doing business with initially, because sometimes it's word of mouth and it's not what you know, it's who you know. So you may know someone else that have did business with that company prior. And so you can kind of get little tips on how do they pay, how do they work with change orders? Are they difficult? So even though that's word of mouth, a lot of that is helpful. Because someone might have a prior experience with that particular contractor or public entity, and it might make you change your mind, of going into bed with them. And you know what I mean? So, because once you're in there, once you ring a bell, it can't be unrung. So I think doing some due diligence, some extra research too, and who you're, going into business with is helpful as well.
I think that's great advice. I think that's fantastic advice. Thank you. It is. No, look them up. It's so easy to look people up these days.
Go to their website, see what type of projects they had. If you know someone who did work with them, ask them, okay, hey, Miss Eleanor, have you heard about anyone doing business with this company? And and it will give you more realistic experience as opposed to someone else you may not know. You know what I mean? So I think that's very important.
And I think also, remember, you're part of NAMAC. NAMAC is a community of contractors who are doing these. And some of them are larger contractors who have done it for quite some time and they know what they're doing. Talk to them, use the resources. Everybody is willing to help each other.
Yes, we're all in this together.
Absolutely, I agree. So let's see, we have Willow. Hi, Willow.
Hi, thanks for all the information. I heard, I believe it was Rakia mentioned like finding out who the owner is. So we ask people on our job sheets or customer sheets, like who's the owner of the building. Sometimes they don't put that information in there. And so in that case, we would be considered a direct contractor. How do we know that they're telling us the truth? Do you just send them the lien anyway, or the prelim?
Yeah, let me ask you something. Remind me what kind of company are you with?
We're an HVAC company.
Okay, and you guys always get a contract, right? Or do you do stuff on POs?
No, we do. We always do a contract. Sure, we're supposed to for bigger projects, but we do service work as well. So,
okay, so for service work, also you should tell them we need to have this and have them email it to you so they can't give you the wrong ones, and then do a little bit of due diligence on it, see, it's easy to pull some county records. It's easy to just Google, for God's sake. I Google.
So I have, and I get conflicting information. And so I'm always wondering, like, what is the most reliable source for getting like owner information?
Obviously, county records are the most reliable sources to get.
Okay.
And there are agencies, I think, out there that would help you with those too.
Yeah, we've used like construction notice services or like companies.
Some companies, I don't know, other contractors
Level Set.
have better information. Yeah.
Who was it? Did someone just say it?
Level Set. Level Set will do all your prelims. They will
Level Set. Yes.
Yeah, they will also do all the research. And once you upload all your, basically you have to upload the 20-day preliminary information that they give you, and they'll let you know if it's correct or it's incorrect, or if they find someone else. They have scouts for that. The service, it's game changer. Better than any of the other ones. I've been in business for 16 years, so I've been using them for the last 3 or 4 years.
Okay.
Fantastic. That's good.
That's good to know, because I was like, well, if we've used it once, if we paid the fee, then is it okay for us just to keep using that information? But the dollars get so big, I'm like, oh, let's just run it every time.
you buy like a membership with them, and let's say for instance you buy for like 5-10 jobs, and you'll get at least 10 jobs during the year. It pays for itself, in my opinion. I used to do it manually with all the forms that they put in right now, but Level Set will definitely do it a lot simpler for you. It was going to cost you, but much safer than you doing it yourself. I could vouch for that.
Yeah, I
Okay,
totally
awesome.
agree, because I used to do this manually before this started. I worked for an HVAC company. I was a controller for 16 years, and they used to call me the lien queen. I'll go down to the county recorder's office in Norwalk. So I would do the certified mail notice. I go to the post office and get the green cards, everything. So the services are really good. But even before that, I think would it be a red flag is this. For one, making sure your contract has the information in there. And if you request it and they're dragging their feet about giving you the owner's
Right, or
the
sometimes
information.
people skip forms.
That'd be a red
or
flag for me, like-
portions.
That's a red flag. Shirokaya
It's
is
a red
right.
flag.
You don't want to
Yeah.
do business with them. If they cannot give you the owner of the project, you kidding
Well,
me?
I'm always wondering if they're like, because sometimes people leave stuff blank and I'm like, is this because you are the owner of the building or is there something else?
Don't-
You know what I mean?
You know what assume does, right?
Yeah, exactly.
Sorry.
It's the truth.
We had a professor in law school who wrote it big on the board one day.
Yeah,
It's like, assuming, don't ever assume, because it may,
right.
and out of you and me. And I'm like, okay, I'll remember that. You can't assume, you always confirm, and you always get them to tell you and be upfront. And if they're not, Rukai is right. That's a big red flag.
That's a big red flag. People's are kings and queens of omission and commission. So, hey, who's the owner? Can I, and then, you shouldn't have to fight for that information.
No,
That's the thing
no.
too. You know what I mean?
You need the
So-
name of the owner and the construction lender. If there's
Exactly.
a mortgage on the property, you need the owner and the mortgager. This is important stuff. You need.
What about, so one more question, because we do service work and some locations we do a ton of service work. So there's not one invoice that's $10,000, but we'll have $2,000.
So I would recommend, we have some HVAC companies who do that. I would recommend to have a master agreement for that.
Mhm.
And if
Yeah.
the owner doesn't have one, you should have one for yourself. We draft
Yeah.
those for our clients. And I'm telling you, Carlos was talking about how you buy it for 10 projects and it saves you, pays for itself. Again, attorneys might be very expensive, but people who come to us from a preventative standpoint, and you tell them, they're going to get into $100,000 contract, they're going to get into $1 million contract. And sometimes they don't want to spend a few $1,000s for a proper contract to begin with.
Mhm.
Well, most of those people I get to see later on, and then they have to pay us tens of thousands of dollars. So you pay a little bit upfront. That's a pound. It's an ounce of prevention worth a pound of cure. For a service, if you're doing a lot of service contracts, you should have your own service contract, and all you do, it's a proper legal document, and what you attach to it for every different job is your scope of work and your price. And then you put in the address and the name of owner, but the rest of it, you can use it over like the level set documents over and over and over again. And it's a contract that will protect your rights later on. If one of these, I know like they're in Orange County, Irvine Company, gives like tens of thousands of contracts out. They have their own contracts. But if someone comes to me and says, well, I'm doing a lot of stuff for for a lot of projects, because you're going to end up putting mechanics liens that are less than 10,000, and you can't go to a small claims court for mechanics liens because that's less than 10,000. You have to go to a small claims court. So having a proper service and agreement, master service, we call them MSAs, it's a very important thing.
Great, thank you.
You're welcome. Anybody else? Okay, so I was gonna, Rakaya, unless you have something, I was gonna talk a little bit about what happens in cases of release bonds. So we've got a person in our office who does our our PowerPoints and came up with Mr. Bond instead of release bonds, but it's a little bit of levity for the middle of a very dry subject. So basically, a lot of times we see that there's a stop notice and there's a dispute, okay? And the public entity may allow the direct contractor to give the public entity a release bond. And what's a release bond? A bond company will do that. So, and the amount has to be equal to about 125% of the claim. So if you have a claim for $1 million, they have to get a release bond for 1.25 million, 1,250,000. And then it is conditioned on the payment of any amounts that then the claimant, you who didn't get paid, will get with court costs and everything if you prevail in a lawsuit. So this is when things have gotten really bad, but I wanted to talk about it because I want you guys, if you hear the term release bond, they say, you know, don't go after our bonds, we will go get a release bond, blah, blah. It costs them a lot of money. So if people are telling you, don't send a preliminary notice, don't file for a stop notice, don't file a mechanics lien, we'll get you paid, blah, blah, blah. That's a big red flag, to use Rukaya's words. Okay, so what happens if there is a release bond? On receipt of a release bond, the public entity cannot hold the funds anymore, okay? It's a bond company that's basically guaranteeing you pay the direct contractor. If the direct contractor cannot pay it, we will pay it, right? But that puts the direct contractor's neck on the chopping block because they have to end up paying anyway. And then that surety or the bond company on a release bond is jointly and severally liable to you. What does that mean? That means that if you go after, file a lawsuit, you file it against both the bond company and the direct contractor, and either or will be joint and several liability means it's the full amount. You can get it from this person and can get it from the other person. It's not half and half. Not that you can get double, but if one of them can't pay, the other one can't say, I'll just pay half of it. It's the full amount against. Well, this is again, another one of those attempts at a joke for release of a bond. This is release of a person from jail. Okay. How to enforce, again, a stop notice. You have to, once there's a stop notice and the required amount of time has passed, the 90 days after you've done, you filed the stop notice, you can, at the latest 90 days, you can file a lawsuit. And that's a regular lawsuit to be filed, breach of contract, foreclosure of stop payment notice, etc. Make sure you don't go 90 days after you file the stop payment notice. When you file a stop payment notice, immediately talk to a lawyer, have them put it on their calendar, have them make sure to ding you a couple of weeks before the 90 days is up to see if you've been paid. If you haven't been paid, then a couple of weeks, give them time to file a lawsuit. You don't file a lawsuit within 90 days for a mechanics lien or the stop payment notice. What happens is that, sorry, I need some water. What happens is that then, again, it becomes invalid. Same as mechanics lien, then it has to be released. And if you don't release it, then they'll go court to court. They make you release the stop notice and make you pay their attorney's fees too. How to minimize exposure for liens and stop notices. If you're a contractor that has subcontractors, keep track of your project dates, even for your, not to lose your right to a mechanics lien and stop notice. Please, please, please. The day you start a contract, has to be recorded somewhere. Write it down somewhere in your office files. Make an office file for your project. The date you start is important because a lot of times you sign a contract and you don't start for a while, right? So the date of start is important. The date you end your job is important. If there's a notice of completion and they send it to you, or you can get it from the city, they file it, get that date. And calendar these days. We've been talking about it over and over and over again, okay? In these are the ways you minimize your exposure, you get paid for the work that you've done. You give preliminary notice every single time. Somebody gets offended, tell them, no, it's not being offended. This is just a company policy. We have to do this. You're gonna pay us, right? So why are you upset? You're gonna pay us, right? File and serve a record and serve a claim of lien or stop notice. Again, Level Set is one of those entities that can do it. We do it for our clients. I don't know, Level Set might be cheaper. But we just do it for our clients who want to get it done. And then pay attention to the notice requirements. Let your attorney know, again, when you finish a project, or file a lien so we can put you on our calendar not to miss the time. And that's all, folks. Sorry, talking too much. Rukayo, I'll pass the ball to you.
You know what? Thank you. I think this was a very informative presentation in regarding prelim, stop notice, and mechanic liens. I think it affects all of us. You on the tail end, you're fixing the issue that we create or don't get in the front of it. But it's always important to be proactive instead of reactive. Just think about in life, when you prepare yourself, you handle things more better when things fall apart, as opposed to being reactive and trying to clean them up after the fact. You know, let's make the lemonade and keep it in the pitcher, as opposed to spilling it over and have to clean up all the mess and have paperwork on the table. Then you have to read. You know what I mean? Let's be ahead of the game. So no, I think this was very helpful, especially for small businesses, contractors, attorneys, because ultimately you're going to fix our mess for us. Thank you for being great and doing what you're doing. It's very informative. You know what I mean? It's very helpful. It's a matter of keeping your business in business.
Thank you, Rukayo, because you brought the perspective of the people right there on the ground doing the work and using this stuff. And I think
Yes.
that's really, really important. I appreciate your.
No, I appreciate you. Thank you.
Thank you. We worked well together. We should take this show on the road.
We need to.
Okay. Well, you also kept it more lively. Who wants to listen to an attorney for an hour and a half anyway, but you know, not all of us are bad. One piece of advice, again, document. Everybody's got a phone. Use these phones. Pictures from the job site when you're doing work. Have your people take photos, keep them in your file, organize your files well. And it's so easy nowadays that everything is electronic. When I used to represent Turner and Whiting Turner way back in the early 2000s, we used to get bankers boxes, maybe 40, 60 for one project. And everything was absolutely proper. There was a folder for each subcontractor in there. And you can do this for your subcontractors, but you know, virtually on your computer. In there was a copy of their subcontract, a copy of their insurance. If there were bonds, copies of those. And then as things progress, you know, there were just change orders, RFIs, all of those copies are kept in one single folder for that project. And if you have subs, in a specific folder in there for them. Keep, you know, have a little folder in your computer for pictures, upload them, keep them, emails, upload them, keep them. So I know I talked a little more than at the end, but I'm very, very passionate about keeping people away from trouble. Tracy, you really want to hear us talk some more? Go ahead.
Tracy.
Tracy raised her hand. You're mute. My friend, you're mute.
Okay, I'm
There
sorry.
you go. How you doing?
Um,
Haven't seen you for a while.
I know. Zoom is our friend, right?
Yeah.
One thing I would say, Mayor, especially for us with small businesses, yes, it is, the dawn of cloud-based everything. But as I know, that in this business, the person with the most paperwork wins. And as Mayor stated, you have to have some type of organization for that paper. And I'm going to give you an example. We worked on a project and some woman slipped and fell. Well, she sued everybody who worked on that project, not when she slipped and fall, anybody that was, she didn't sue, I'm sorry, she named them in the case, everyone who worked on that project, be it the day she fell or whenever. Well, because we had our paper, real paper, organized in such a manner, we were able to find that file with the real paper in our dailies. We were able to show her or show, for the court that we weren't even there at that time. So it's just so important that you have some type of system that when you need something, you can put your finger on it, because it can save you a whole lot of time and money. That's it.
And Tracy, daily field reports are one of those things that a lot of contractors that I see don't have, and we always include that in our in the form packet that we send to our clients. It's like, for God's sake, have somebody fill out a little something. Now, there's software right now that larger companies, they have software for the daily reports. Now, I agree, paper is great. I'm a big fan of, we have very little paper in our office anymore, but that's because we have 2 disks in the office that are mirror images of each other, plus 2 backups to the cloud. And so, in addition to that, I back up by hand, every month.
Wow.
So we make sure that if one of them fails, we have everything else. But yeah, for the longest time, we had paper and cloud and, electronic. Whatever you do, keep it organized. It's so true, so true. And I know you guys have become much bigger now. That's one of the reasons, because you're very organized.
Thank you.
Thank you
Bye.
all.
Thank you.
I think that's it, right? Anybody else? Let's go home and have dinner.
Well, I want to say you guys were phenomenal together. I love Rakaya saying that she is the queen of lean. We're going to put that on the t-shirt. That should be your tagline on your business card. I remember when you was running to them offices, child. I know.
You remember, honey, back in the day, honey.
No, and you was no joke. So thank everybody for
Thank you.
taking the time to join us for this great workshop. This is the kind of benefit you get when you are NAMAC members. So for those of you that are not NAMAC members, you might want to think about joining this fabulous family. Working together is what, raises everyone. So as the saying goes, when one rises, we all rise. So thank you guys. Yes, I am ready for dinner. It's 4th of July food leftovers.
Leftovers.
That's good.
It's always better than that.
Ellen, can you send Chris's information to me? Because he had a question about federal projects.
Okay,
Well,
and his name
if you
is
can
Chris.
send- let's see.
Which Chris? I see
Yeah.
Chrissy. Oh, Chris.
Chris.
Uh,
I'm a big
Okay, you know what,
Is he-
Myar,
he
I
may
will-
have left.
I
Okay,
will send
he's,
you the list of,
he's the one who's, yeah, that would be good. So then I'm a firm believer you do what you say you're gonna do. So
And
I.
that's why
You know
this
what?
is-
He left it in his email in the chat. He's
Oh, he
Chris at
did? I
DS.
didn't see it.
Chris
Let me-
did.
Yes, ma'am.
There you go.
Chris at dsyourman.com.
There
So
you
it's in the
go.
chat.
Chris at diazyourman.com. Beautiful.
Yes,
Let me
love it.
copy that right now. Thank you. I didn't see it. I will do that. Thank
This was so great. I appreciate
you.
everyone.
Thank you.
You know, time is something you can't get back, but information is priceless. So
Amen. Amen.
Absolutely.
Oh, you good? You got it. You rolling today, Rakaya? Come on, you got all of the good lines.
I've been doing this long enough, buddy. I should pick up on something, right?
All right, everyone.
Thank you, Ellen.
Thank you, guys.
Say
I
hi.
appreciate it.
Have a
Please
good.
say hi to Sharon.
I
Take care.
will.
Okay,
I
bye-bye.
Have a good
Bye-bye.
remaining work week, you guys. Be safe.
And thanks to those who participated.
Amen.
Thank you.
Bye-bye.
Thank you. It's very
Bye.
informative.
Bye-bye. You're welcome.